Hello, and thanks for downloading this podcast. My name is Killalea. I am a partner and head of the employment team at Maples and Calder, Ireland, the Maples Group's law firm in Dublin. Before we jump into today's subject, just the usual housekeeping. If you are listening in from your usual podcast app, you'll find any resource documents and speaker bio information in the description. If you've clicked on the media player link sent to you by email, you can find this information in the notes section. Please note, this podcast contains a general overview of managing performance issues in the workplace and elements of this that might be of interest to you. It does not constitute legal advice, and if you have a specific situation or question, please reach out to one of our team. And last but not least, don't forget to subscribe on Apple Podcasts, Spotify or Google Podcasts to our Maples Irish Employment Law series. I'm joined again today by my colleague Ciara Ní Longaigh, who's an associate on the employment team here at Maples. And in today's episodes, following up on our theme of managing change, we thought it would be helpful to look at the specific issue of managing performance in the workplace. As we do so, we're going to look at a number of very typical questions or issues that Ciara and I see arising in practice, and they are the following. So number one, we're going to look at what the basics are. What does an employer need to get right in terms of performance management? Number two, we look at the issue of performance management during probation. We'll then move on and look at the kind of tricky issue of managing performance versus managing misconduct and how you handle absence during a performance management process. We are then going to touch briefly on redundancy and guiding employers to make sure that redundancy is used for restructure and not for performance issues. We'll talk a little bit about absence during performance improvement plans. We will then spend a little bit of time looking at performance management for the purposes of compliance with the new individual accountability framework, which is, of course, of relevance to regulated financial services employers. Finally, we will look at the risks that may arise in practice if an employee is dismissed on the basis of performance. Okay, so Ciara, before we look at all of those issues, maybe let's start with a regular performance management process. What are the basics that an employer needs to get right in order to reduce the risk of performance management issues in the workplace getting out of hand?
Well, as a starting point, employers should ensure that they are carrying out standard annual reviews or appraisals for all employees. Meeting with an employee regularly to discuss performance can catch any potential issues early, and having regular documented feedback can assist the employer down the line if formal performance issues do arise. It's important for an employer to set performance objectives and to apply a clear procedure to assess whether standards are being achieved by the employee and whether objectives are being met. Employers should ensure that they have a robust performance management policy in place which deals with how performance issues will be dealt with. In our experience, employers will sometimes include the performance management process in the disciplinary policy. Whether the process is set out in a standalone policy or as part of the disciplinary policy, clear guidance should be set out to outline how an employee's performance is to be managed when issues do arise. If performance issues arise and the employer is satisfied that an informal process is not sufficient in order to address the issues, an employee should be placed on a performance improvement plan or a PIP. PIP will generally run for between 8 to 12 weeks and will involve regular meetings with the employee by reference to clear objectives which have been set out in a PIP document at the beginning of the process. The key to running a smooth PIP process is communication, and we recommend that employers meet with the employee before commencing a PIP to agree the parameters and the objectives of the PIP. This will give the employee a chance to voice any concerns that the objectives set are unachievable or unrealistic for any reason. The employee should be asked to sign the PIP document in order to ensure that a written record of their agreement is obtained.
Okay, thanks, Ciara. The foundations are important for sure, but there are some guardrails around that. And there's a really interesting, a very recent case that has just been reported on, Caroline McGarry versus JT Ireland. Can you just talk us through the key points arising from that?
Yes, absolutely. The decision provides a cautionary tale for employers on the consequences of incorrectly implementing a PIP process. In this case, an employee had been absent from the workplace for 3 months during the year 2021. When the employer carried out a 2021 performance review meeting with the employee in January 2022, the employee was labelled as needs improvement. In March 2022, the employee was labelled as an inconsistent player. in the employer's scoring matrix. And finally, a couple of months later, in May 2022, the employee was informed that a PIP was to be initiated. In response to the initiation of this PIP, the employee later resigned and claimed that she had been constructively dismissed due to the actions of her employer. In this case, the WRC was not satisfied that there was clear and open informal discussions throughout the year of 2021. Although the need for discussion and feedback was arguably heightened due to the employee's long periods of absence throughout 2021, the WRC did not consider an appraisal of the employee's performance to have been carried out appropriately. The WRC noted that the impact of the complainant's illness, even on her return to work, had not been taken into consideration in determining next steps with respect to her performance, and the employee was awarded compensation of €40,000 for unfair dismissal, which was the equivalent of 6 months' remuneration.
That's great. Thanks, Ciara. And I know you have one or two other cases that we're going to come back to towards the end of the podcast, which also sort of highlight the pitfalls of wrongly activating a PIP. So we'll come back to that in a minute, but that's extremely interesting. It's worth mentioning as well, I think, just to kind of set the scene, that the driving force behind a performance improvement plan is to coach and encourage the employee, as distinct from punishing the employee in any form. So the starting point is that it's the employer's responsibility to take reasonable steps to restore an employee to a satisfactory level of performance. But obviously the employee has a very considerable responsibility as well to engage in that and to participate and to try to bring their performance back up to a reasonable standard. So reasonable performance management is permitted, and it does not, for example, constitute bullying. And in fact, it is specifically carved out of the well-established definition of bullying that applies in an Irish employment law context. So as I mentioned, the employee does have a responsibility to engage and to participate in the PIP to the best of their ability. If an employee does have concerns or objections, they absolutely need to be discussed and worked through. But fundamentally, both parties need to engage, and reasonable performance management, including using a PIP, is really the well-established means by which good performance should be restored. It's worth also mentioning a very interesting decision from the Supreme Court in Ruffley versus the Board of Management of St. Anne's School. In that decision, the court noted that in terms of whether a performance improvement process could constitute bullying, the court said that you need to look at the manner in which the process is conducted and the intent behind instituting it, and that's of primary importance. So, for example, performance improvement process that is instituted maliciously, that clearly could constitute bullying. But in the vast majority of cases, in our experience, employers don't do that, and they use the PIP process appropriately. It's interesting that Mr. Justice Charlton, in that judgment, the Ruffley judgment that I just mentioned, he said as follows in relation to distinguishing normal performance management from bullying. He said, correction and instruction are necessary in the functioning of any workplace, and these are required to ensure that productive work is engaged in. So turning now to managing performance during probationary periods, Ciara, would you talk us through the very interesting overseas technology decisions resting with the Court of Appeal?
Yes, absolutely. And many listeners will no doubt be familiar with the decision. Briefly, this case involved the dismissal of a CFO during their probationary period. The employee's contract of employment stated that his performance would be assessed during the period and that his employment would continue if it was satisfactory. The contract incorporated the disciplinary rules and procedures contained in the employee handbook and provided for a right of appeal against any disciplinary action. The employee was dismissed during his probationary period on the grounds of poor performance and subsequently issued High Court proceedings restraining his dismissal and seeking to be reinstated, claiming that he was dismissed for misconduct in breach of his contract, which he argued included an implied term that the disciplinary procedures should be used to address a performance issue, and that as such processes should be carried out in accordance with natural and constitutional justice. The High Court found that Mr. O'Donovan had established a strong case that he had an implied contractual right to fair procedures in the assessment of his performance during his probationary period, which had been breached in this case by his dismissal. Significantly, the High Court did not accept Mr. O'Donovan's claim that he was dismissed on the grounds of misconduct, but nevertheless held that he had established a strong case that his dismissal was not lawful, as it was held the obligation to afford an employee fair procedures in relation to his dismissal.
Thanks, Ciara. Just to jump in momentarily on this, I think this briefly represented a concern for employers who, up until this time, perhaps had felt that the standards applicable to managing performance were not quite as demanding or as, in inverted commas, judicial as they are when managing an allegation of misconduct. But in any event, the situation was relatively short-lived because the matter then was appealed by the employer.
Yes, exactly. This decision was then appealed to the Court of Appeal by the respondent employer. The Court of Appeal agreed that Mr. O'Donovan had not established a strong case that his dismissal was for misconduct. However, the Court of Appeal decided that the High Court had failed to give adequate weight to the fact that the termination occurred during Mr. O'Donovan's probationary period, a period during which, to quote the Court of Appeal, both parties are and must be free to terminate the contract of employment for no reason or simply because one party forms the view that the intended employment is, for whatever reason, not something which they wish to continue. Notably, the Court of Appeal did not accept that a court can imply a right to fair procedures in relation to the assessment of an employee's performance during the probationary period, as it would negate the whole purpose of a probation period. However, the Court of Appeal pointed out that one exception to this is where an employee is dismissed for misconduct. In such cases, the principles of natural justice apply and fair procedures must be followed. It's therefore clear that while there may be some scope to apply a truncated process in respect of an employee in relation to their performance issues during their probationary period, where there are any allegations of misconduct, an employer must run a full and fair disciplinary process with regards to the principles of natural justice.
That all seems pretty clear. And just on that point of misconduct versus performance, there's an interesting decision of the High Court in Buttimer versus Oak Fuel Supermarket Limited, trading as Cost Cutter Rathcormac. The High Court determined that the mere fact that certain conduct might also be considered as a performance issue doesn't prevent it from being misconduct. In other words, a misconduct issue can be related to a performance issue. So, for example, perhaps a one-off and very serious mistake or omission that turns out to be business critical for an employer. But typically, performance and misconduct are separate. One other point, actually, that I wanted to pick up on is the importance of note-taking. The court had some interesting points to make about having contemporaneous documents in relation to a performance management process. The High Court in particular was very critical of the fact that there was not a single contemporaneous document recording any feedback given to the employee in question. And the court noted that you would expect that if the performance concerns were as serious as were claimed by the employer, and if in fact goals and dates were set for the employee, then there would be some contemporaneous note or memo of that interaction in relation to performance. But on the facts of the case, there was not. The court also noted that the absence of any feedback or training records was particularly noteworthy in circumstances where the defendant employer had agreed that the employee had no experience in a management role, but had the potential to become a good manager. So, look, this approach is consistent with the long-standing position that the courts will carefully look at these and carefully examine the real reason for dismissal. And that sort of brings us nicely into our next piece, which is around redundancy, and perhaps a redundancy being incorrectly used to manage a performance situation. So, Ciara, can you just tell us a little bit more about how the courts have approached this topic?
Yes, absolutely. Employers should keep in mind that the correct venue for dealing with underperforming employees is the performance management route, with the use of a PIP, as we've mentioned, where applicable. Crucially, performance management issues cannot be dealt with by cherry-picking the employee for dismissal by reason of redundancy. This is an avenue raised occasionally by well-intentioned employers who want to manage an exit of an underperforming employee without confrontation, and perhaps by even offering a redundancy package to try and keep both parties happy. The decision of JVC versus Panisi sent a stark warning for employers that redundancies need to be clear and transparent and, above all, genuine. In this case, an underperforming general manager role was selected for redundancy. The employee successfully argued that the redundancy was not genuine on the basis that the position still existed within the company and that he had been dismissed for poor performance. The employee was awarded €197,000 in damages in addition to an ex gratia payment that the employee had already received.
Thanks, Ciara. That's quite an old decision. It was an absolutely eye-watering amount at the time, and it's still good law, so that's good to note. Let's turn to the next point, which is about absence and the impact of an absence on a PIP. So what happens when an employee is put on a PIP and then they're absent for a period of time? Do you want to talk us through the Moran versus McDermott Laboratories case?
Yes, absolutely. In this case, the employee had failed a first PIP, which she had been placed on, and she then subsequently took a period of stress-related sick leave the day after her employer informed her that she had failed the PIP. Following this period of absence, a second 6-week PIP was initiated by the employer. The employee claimed that she had been set up to fail and that she had been constructively dismissed. The WRC, in its decision, accepted that the initiation of the second PIP upon the employee's return was reasonable and an effort by the employer to see if the problems could be fixed amicably without recourse to other areas such as the disciplinary procedure.
That's great. Thanks, Ciara. And listeners may be aware that in our last podcast in this series, which was dropped a little while ago and is available on our website and on the usual platforms, we actually looked in some detail at the whole issue of managing absence and supporting employees returning to work. So you might want to take a listen to that as well, just to get another angle on the managing absence issue. Okay, so listen, all of that provides a relatively seamless segue into our next topic, and that is what next in the case of an unsuccessful PIP. So, Ciara, can you talk us through that?
Well, following an unsuccessful PIP, an employee then moves into the disciplinary procedures, and a disciplinary meeting should be arranged with the employee. The proper application of the disciplinary procedure in this situation will ensure that the rules of fair procedures and the principles of natural justice that we've mentioned are applied to the employee. Under Section 6.4 of the Unfair Dismissals Act, a reason for dismissal which may be considered fair is where the capability, competence or qualifications of the employee for performing work of any kind which he is employed to do. It is reasonable for an employer to initiate a PIP and, following an unsuccessful conclusion of that process, apply the disciplinary procedures to the employee, with the outcome being that an employee is dismissed on the grounds of capability or performance, so long as proper procedures are followed. We just need to keep in mind that the employee is owed fair procedures and the principles of natural justice should be afforded to the employee in such situations. That is, the employee has the right to be fully aware of the case that they need to answer, to reply to the case being made against them, to be accompanied to the disciplinary meetings by a colleague, and the right of appeal in relation to the outcome of the disciplinary procedure.
Thanks, Ciara. And again, we have spoken in some detail about fair disciplinary procedures in our previous podcast, which is also available as part of this series on our website and on the podcast platforms. Turning to the remedies that are available to an employee who believes that they have been unfairly dismissed on the basis of poor performance. Can you just take us through the key guidance, Ciara, in relation to that?
Well, as we've mentioned previously, an employee may resign and attempt to claim that they have been constructively dismissed, as the conduct of the employer has been so unreasonable that they had no option but to resign. If an employee is successful in such a claim under the Unfair Dismissals Act, they may be awarded compensation of up to 2 years' remuneration, limited to financial loss, of course. It is important to note that the burden of proof is on the employee in such cases, and it's a very high bar in terms of demonstrating that the conduct of the employer was so unreasonable that it justified a resignation. An interesting example of this type of claim can be found in the decision of a former regional manager and health and safety manager versus a vehicle services company, where an employee claimed that he had been micromanaged under a poor performance management procedure instead of being afforded the support that he indicated he would have needed as he was suffering from work-related stress. The main issue which the WRC considered was whether the respondent's conduct towards the complainant, in particular its decision to place and or retain him on a PIP, was so unreasonable as to justify his resignation. The WRC decided that, as the respondent had been well aware of the complainant's personal difficulties before implementing the PIP, The imposition of the PIP had been a breach of the respondent's performance improvement policy, and therefore there had been wholly disproportionate response from the outset. Further, the actual implementation of the PIP had been flawed. Apparently, it lacked a defined means of objectively measuring the complainant's performance. The WRC noted that the PIP meetings descended into general discussions about day-to-day issues as opposed to setting performance-related targets and timelines. The WRC also noted that the open-ended nature of the PIP was concerning and that the complainant had actually been deemed to have reached an acceptable level of performance but was not taken off the PIP. In this instance, the PIP had been labelled by the employer as a poor performance management plan, which was described by the WRC as a self-fulfilling prophecy, which only served to compel the employee to resign. The employee in this case was awarded €46,500 in respect of his constructive dismissal claim.
Thanks, Ciara. There's plenty in that decision, certainly, to digest and reflect on. I just want to mention one final point, which is relevant to our listeners who are employers in the regulated financial services sector, and they will be very familiar with the individual accountability framework, most of which is due to come into force imminently and over the course of the next 6 months or so. But I just want to point out the importance of using a fit-for-purpose performance management process to help drive compliance with the new common conduct standards and the additional conduct standards, and to continue to drive compliance with the existing fitness and probity standards that apply to all of those in-scope employees in the regulated financial services sector. So those employers in that sector will be required to ensure that all of their in-scope employees are appropriately trained and managed so that they can take reasonable steps to comply with their new obligation. Attendance, for example, at mandatory training and compliance overall with the conduct standards. And for the more senior employees, the PCFs, their adherence to and discharge of their individual responsibilities should form part of the performance management discussions. Okay, so just to wrap up, I think, and to pull all of the threads together, it's clear that a performance improvement plan needs to be implemented in a fair and transparent manner. Employees should be provided with clear feedback on a regular basis, as we've discussed, and where possible, it's good to try to resolve these matters, first of all, informally, but then if it needs to escalate to the formal process and use whatever your handbook says is the correct process to use in the given situation. If you don't have a performance management policy, you should think about putting one in place, and in particular, clarifying how that ties in with your disciplinary procedure. Where a PIP is implemented, as far as possible, it should be implemented with the employee's input. So if there's any need to perhaps recalibrate some of the performance indicators or the duration, you should try to get those things ironed out at the beginning. Okay, so I think that's everything for this episode. Thank you for listening to the Maples Group Employment Law podcast, and thank you for your feedback. We've got some really great feedback from our listeners, and we appreciate that. So as always, if you have any questions or queries in any of the points covered today or on Irish employment legal issues in general, please do get in touch with us.